I can defend him. The voice is small, barely above a whisper, but it cuts through the chaos of that courtroom like a blade through silk. Every head turns. The judge looks up from his papers. The prosecutor lowers his pen. The jury, 12 men, and women who haven't agreed on a single thing in 3 days, all go quiet at exactly the same moment. Standing in the back of the courtroom is an 8-year-old boy in a shirt 2 sizes too big for him, collar buttoned wrong, shoes with a hole in the left sole. His name is Marcus Webb. He has $11.43 to his name. He has never set foot inside a law school. He has never worn a tie in his life. But he has something the abandoned millionaire's team of expensive attorneys never bothered to find: the truth. And in 47 minutes, that truth will change everything. 3 weeks before that courtroom moment, Marcus Webb woke up at 5:15 in the morning the way he always did, not because of an alarm, but because the pipes in their apartment building groaned like something alive when the boiler kicked on. The sound traveled through the walls of every unit in the Garfield Street complex. Most residents had learned to sleep through it. Marcus had learned to use it. He was up before his mother, before the sun, before the city remembered it was supposed to be running. He made 2 slices of toast with the last of the bread, left one on the counter with a napkin folded underneath it, the way his mother liked, took the other one with him to the window, where he sat cross-legged on the sill, eating and watching the street below with the focused attention of someone twice his age. Marcus watched everything. That was the thing about him that the people in his life sometimes found unsettling, and more often simply failed to notice at all. He watched how the bodega owner on the corner stacked his fruit in the morning to hide the bruised ones underneath. He watched how the bus always ran 4 minutes, late on Tuesdays but was almost always on time on Wednesdays. He watched the way people's faces changed when they thought nobody was looking at them. He watched, and he remembered everything he saw. His teacher, Mrs. Okonkwo, called him a sponge. His mother called him her little detective. The other boys in the building didn't call him anything because they were mostly a few years older and Marcus didn't fit neatly into their world. He was fine with that. He had his notebook. The notebook was a composition book, black and white marbled cover, purchased from the dollar store on Clement Avenue. He kept it tucked inside his backpack between his reading textbook and his extra credit math worksheet. In the notebook he wrote observations, not diary entries, not feelings, observations, precise, factual, dated. October 7th. The white car with the cracked windshield has been parked on the east side of Garfield since Monday. Engine is warm in the mornings. Someone is sleeping inside. October 9th. Mr. Delacroix on the 4th floor got a certified letter at 9:22 a.m. He stood at the mailbox for 6 minutes before opening it. Then he sat down on the lobby stairs and put his face in his hands. October 14th. The man in the gray suit came back to the Meridian building across the street. This is the 3rd Tuesday in a row. He always checks the street in both directions before going in. He never carries anything going in. He always carries a briefcase coming out. Marcus Webb had been watching the Meridian building for 8 days by the time everything began. Ethan Calloway was 17 years old, lived in a glass and steel apartment on the 42nd floor of a residential tower downtown, and had never in his life made his own breakfast. He had also never, in his life, asked for any of the wealth that surrounded him. It had arrived with his grandfather's death 3 years ago, a trust fund that made people in certain law offices say numbers with a great many zeros out loud before they caught themselves. The apartment, the school, the accounts, all of it arranged by trustees and attorneys and financial advisors who moved pieces of his life the way chess players move pieces on a board, carefully, strategically, and with very little interest in what the piece itself might want. What Ethan wanted was to study marine biology at a small university in Oregon. He wanted to eat cereal for dinner sometimes. He wanted to be ordinary, which was the one thing his extraordinary inheritance made impossible. The arrest happened on a Tuesday evening. The charge: theft of rare documents from the Meridian Historical Archive, a private collection housed in a building that Marcus Webb had been watching from across the street. Specifically, 3 original letters believed to be authored by figures from the early constitutional period, each valued by the archive's insurance assessment at between $400,000 and $900,000. Combined value, over $2 million. The evidence against Ethan Calloway looked on the surface overwhelming. His name appeared in the visitor log for October 14th. Security footage placed him in the building at 4:17 p.m. A partial fingerprint recovered from the display case matched his, and when investigators searched his apartment, they found a photograph on his phone, taken from inside the archive's secure viewing room, that showed the documents in question lying on a table, Ethan's hand visible at the edge of the frame. Ethan's lawyers, 4 of them, billing collectively at rates that would make a surgeon blush, spent 3 weeks building a defense that collapsed on the first morning of trial when the prosecution revealed a piece of evidence they hadn't disclosed. Until the last legally permissible moment. A witness, the witness, a man named Gerald Price, stated under oath that he had been inside the Meridian building on October 14th and had personally observed a young man matching Ethan's description carrying a leather portfolio case out of the secured archive room at approximately 4:45 p.m. That was when lead attorney Harrington Foster did something that left Ethan's mother gripping the gallery railing and the entire defense table in stunned silence. He stood up, buttoned his jacket, gathered his papers, and said that in light of this new testimony and the totality of the evidence, he could no longer ethically represent a client he believed to be guilty. He walked out of the courtroom. The 3 remaining attorneys followed him like ducklings, expensive ducklings, but ducklings nonetheless, single file through the mahogany doors. Ethan Calloway sat alone at the defense table. He was 17 years old. He had not stolen anything. And now he had no one. In the gallery, a small boy in a too-big shirt pressed his nose against the wooden railing and stared at the back of Ethan's head. His hand moved to his backpack. His fingers found the marbled cover of the composition notebook. Marcus. Webb had been in this courtroom for a different reason entirely. His mother worked as a clerk in the county offices 2 floors below. She had told him to wait for her in the hallway. He had, for approximately 4 minutes, before the sound of shouting from inside courtroom 7 had drawn him through the double doors like a compass needle finding north. He had been watching for 11 minutes when the lawyers walked out. He watched Ethan's shoulders, the way they caved inward, the precise geometry of someone understanding that they are completely alone. Marcus had felt that before. He knew what it looked like from the outside. He stood up. The judge, the Honorable Patricia Weston, had seen a great many things in 23 years on the bench. She had seen a defendant propose to his attorney mid-trial. She had seen a prosecutor fall asleep during closing arguments. She had seen a juror attempt to take the evidence box home in a tote bag, apparently by accident. She had never seen an 8-year-old boy raise his hand in the gallery of an ongoing felony trial. Order, she said, though there was no disorder, just silence and confusion, which are different things entirely. Your Honor, the boy said, because he had read enough to know that was what you said. I can defend him. The prosecutor, a man named Davidson who had won 31 of his last 32 cases and had opinions about time being money, opened his mouth. Judge Weston raised one finger in his direction. He closed it. She looked at the boy for a long moment. Then she looked at Ethan, who had turned in his chair and was staring at Marcus with an expression that had no name in any language. Then she looked at the empty defense table, then back at the boy. Come forward, she said. Marcus walked down the center aisle. His left shoe made a quiet scraping sound with every step because of the hole in the sole. He stopped at the bar. He looked up at the judge the way a person looks up at a building they intend to enter. What is your name? Marcus Webb, ma'am. Your Honor. Ma'am. One corner of Judge Weston's mouth moved slightly. How old are you, Marcus? 8. Do you understand what's happening in this courtroom? Yes, Your Honor. That man's lawyers left because a witness said he saw him carrying something he didn't carry. But the witness is lying. The gallery stirred. Davidson was on his feet. Objection, Your Honor. This is a child. This is irregular. It's also interesting, Judge Weston said. She looked at Marcus. Why do you believe the witness is lying? Marcus unzipped his backpack. He removed the composition notebook. He set it on the railing in front of him with both hands, the way you set down something you've been carrying for a long time. Because I watched the building for 8 days, he said, and I saw what actually happened. Here is what the investigators had not done. They had reviewed the building's internal security footage. They had interviewed the archive staff. They had processed the physical evidence with efficiency and professional competence. What they had not done, what it had occurred to nobody to do, was look out the window of the low-income apartment building directly across the street, at the angle a small boy might occupy while sitting on a window ledge eating toast. Marcus had a clear, elevated, unobstructed view of the Meridian building's main entrance, its secondary side door, and 40 feet of the adjacent alley. He had been watching since October 7th, 11 days before the theft, when the cracked windshield car had first appeared and something about its presence had snagged in his mind the way a splinter snags on cloth. He opened the notebook. His handwriting was careful and small, tilting slightly left, the way left-handed writers sometimes tilt when they're trying very hard to be neat. October 14th, he read aloud, his voice steady for a child who was standing in front of an increasingly restless courtroom. 4:11 p.m. A young man with light hair and a blue jacket. He paused to glance at the photograph entered into evidence, the one showing Ethan in his clothes that day. Entered the Meridian building. He kept reading. 19 p.m. A different man, heavy coat, gray, came out the side door of the building. He was carrying a leather case, brown, rectangular. He put it in the trunk of the white car with the cracked windshield. The gallery went completely silent. 23 p.m. The white car left going north on Garfield. License plate. He read the number. I couldn't see the last digit because a delivery truck was passing. Davidson was already moving toward his table, already reaching for something, already understanding that something beneath his carefully constructed case had begun to crack. 31 p.m. The man in the gray coat went back inside the side door. He was not carrying anything. 45 p.m. The young man with the blue jacket came out the main entrance. He was carrying only his phone. Nothing else. Marcus closed the notebook. The courtroom was so quiet that when Judge Weston set down her pen, the sound of it touching the bench was audible in the back row. That, Marcus said carefully, is not the same as what the witness said he saw. Judge Weston called a recess. In the corridor, things moved very fast in the way that things move when a room full of professionals suddenly understands they have been looking at the wrong thing. Davidson made 3 phone calls in 6 minutes. The third call lasted 45 seconds. When he hung up, his face had a quality that his assistant had never seen on it before. It was the quality of a man who has just realized that his 31-1 record is about to become irrelevant. The license plate number in Marcus's notebook, minus the last digit, matched a partial plate that had appeared in the background of unrelated street footage from 2 blocks north of the Meridian building at 4:27 p.m. on October 14th. Traffic camera footage that no investigator had requested because no investigator had known there was a car to look for. With 8 of the 9 characters confirmed, the database returned 7 possible registrations. 6 were immediately ruled out. 1 belonged to a 1997 sedan registered to a man named Carl Vreeland, 44, with a previous arrest for receiving stolen property in another county, and, when detectives pulled his phone records within the hour, several text messages in the days before and after October 14th that contained the phrase "my friend at the archive," the phrase "the documents we discussed," and with a specificity that investigators would later describe as remarkable given the circumstances, the phrase "the kid walked in right on schedule, easy cover." Gerald Price, the witness who had testified that he personally observed Ethan carrying the portfolio case, had 3 things in common with Carl Vreeland. They had attended the same high school. They had worked at the same warehouse in 2019. And Gerald Price had received a wire transfer of $6,000 on October 15th, the morning after the theft, from an account that traced after 2 intermediate steps to a shell company associated with a private antiquities dealer who had made significant public statements about the constitutional letters being undervalued by the archive. By the time recess ended, 3 investigators were en route to Gerald Price's address. 2 more were attempting to locate Carl Vreeland. A 4th was applying for a warrant. Ethan Calloway sat at the defense table and stared at the notebook that Marcus had left there when the boy went to use the bathroom, because 8-year-olds have to use the bathroom regardless of the historical significance of the moment. Ethan read a few pages. He didn't read the October 14th entry. He read an earlier one. October 9th. Mr. Delacroix on the 4th floor got a certified letter at 9:22 a.m. He stood at the mailbox for 6 minutes before opening it. Then he sat down on the lobby stairs and put his face in his hands. There was a note underneath it, written smaller than the rest as if Marcus wasn't sure he should include it but couldn't leave it out. I think he was scared. I think whatever was in the letter was something he didn't know how to handle alone. I wanted to go sit next to him, but I didn't know if that would be okay. Ethan set the notebook down very carefully. When Marcus came back from the bathroom, Ethan looked at him for a long moment. Then he said simply, "Thank you." Marcus sat down, in the chair next to him. He folded his hands on the table the way he had seen lawyers do in movies. "They haven't dropped the charges yet," Marcus said. "We still need to get through the rest of it." Carl Vreeland was apprehended at a bus station 40 miles outside the city at 3:17 in the afternoon, carrying a backpack and a one-way ticket. The leather portfolio case was not with him. Gerald Price was taken into custody at his apartment, where investigators found a second phone, a burner, prepaid, with messages that made even the most experienced detective in the room set it down and take a slow breath before picking it back up. But the leather portfolio case, the documents themselves, were gone. For 2 hours, this was the problem nobody could solve. It was Marcus who solved it. He was sitting in the corridor outside the courtroom with a juice box that Ethan's mother, a small, carefully composed woman named Helen Calloway, had retrieved from a vending machine while alternating between thanking Marcus repeatedly and crying quietly into a paper coffee cup. Marcus was reviewing his notebook. Not the October 14th entries, earlier ones. October 8th. The man in the gray coat left the building at 6:44 p.m. He walked 3 blocks north and turned left on Bremer Street. He came back 22 minutes later without the briefcase he had taken in. He was in the Meridian building for 9 minutes total, and then October 11th. The same man, same route, left at 6:52, back at 7:19, same pattern, no briefcase going, no briefcase coming back. Marcus chewed on his straw. He thought about this. He had assumed, because it was the reasonable assumption, because most of the things people carried into buildings they carried back out, that Vreeland had been leaving things somewhere. A storage space, a locker. A second location he used as an intermediary. 3 blocks north and 1 block left was Bremer Street. Marcus had not been to Bremer Street personally, but he had studied the neighborhood map in his social studies atlas the way other children studied sports statistics. 3 blocks north of Garfield on the Meridian side was Teller Avenue. 1 block left on Teller was Bremer. And on Bremer, at the corner, there was a self-storage facility called City Vault that advertised climate-controlled units on its awning. Marcus stood up. He walked to the nearest detective, a woman named Rivera, who had been coordinating the investigation, from a tablet in the corridor. "I think I know where the documents are," he said. Rivera looked at him. He had been surprising people all day. She had reached the point where she just accepted it. "Tell me," she said. He told her. Unit 114 at the City Vault facility on Bremer Street was registered to a business name that was, after 15 minutes of database work, confirmed to be one of 7 entities connected to the same network of shell companies already appearing in the investigation. Inside, in a climate-controlled space barely larger than a bathroom, investigators found the leather portfolio case. Inside the portfolio case, wrapped in acid-free tissue paper of the kind used by archivists, were the 3 constitutional-era letters, undamaged, untouched. The lead investigator, a man named Okafor who had been in document theft cases for 11 years, examined the wrapping with the practiced attention of someone who understood what they were looking at. They were planning to hold them, he told his colleague. Not sell immediately, wait until the investigation cooled, classic approach for high-profile items. They would have been patient. The search warrant for the antiquities dealer's office was signed at 4:48 p.m. The dealer, a man named Alderton, who wore bow ties and had been quoted in 3 magazine profiles about his passion for historical preservation, which is the kind of irony that makes courtrooms go very quiet, was located at his gallery and asked to accompany investigators downtown. He was cooperative, in the way that people are cooperative when they understand that the cooperation window is closing and what comes after it is considerably worse. By 6 p.m., Gerald Price had amended his testimony. The amended version contained no young man in a blue jacket carrying anything. It contained instead a description of being approached by Vreeland 2 weeks before the theft and offered money to say what he had said under oath. "Why did you do it?" the detective asked. Price stared at the table. "Because I needed the money," he said. "I thought the kid had money. I thought it wouldn't matter as much to him." The detective wrote this down. She did not respond to it. Some things don't have a response that fits in. A police report. Court reconvened at 9 a.m. the following morning. Ethan Calloway sat at the defense table. Next to him, in the chair technically designated for second counsel, sat Marcus Webb, who had been given permission by Judge Weston to remain in that position for reasons she described as both legally unorthodox and, given the circumstances, entirely appropriate. He was wearing a different shirt. Helen Calloway had quietly taken care of that. Still slightly too big. He had declined the new shoes. He said his shoes were fine. The prosecutor Davidson stood. What he said took 11 minutes and was, by every account of everyone who was present, one of the most thorough and graceful acknowledgments of being wrong that any of them had witnessed in a professional setting. He detailed the full nature of the conspiracy. He presented the recovered documents, still in their acid-free tissue wrapping. He presented the financial records connecting Alderton to Vreeland to Price. He presented the traffic camera footage, the city vault records, and with a citation that he delivered in a tone of genuine respect. The observations recorded in a black and white marbled composition notebook over a period of 8 days by a child who had been paying attention when no one else was. He moved for immediate dismissal of all charges against Ethan Calloway. "Granted," said Judge Weston. She waited for the gallery noise to subside. Then she did something she had not done in 23 years on the bench. She stepped down from the raised platform. She walked to the defense table. She looked at Marcus Webb directly. "Young man," she said, "you did something remarkable. You noticed what trained professionals missed. You recorded it with care and precision. And when you had the opportunity to speak, you didn't hesitate." Marcus nodded. He was working very hard to maintain the expression of a person who was not overwhelmed. "Why didn't you hesitate?" she asked. "Because he looked the way Mr. Delacroix looked," Marcus said, "when he got the letter. Like something was happening to him that he didn't know how to handle alone, and he needed someone to come sit next to him." Judge Weston was quiet for a moment. Then she straightened. She returned to her bench. She composed herself in the way that people compose themselves when they are feeling something they have decided to feel later, privately. "This court is adjourned," she said. Her voice was its usual professional weight, but her eyes, just before, she looked down at her papers, rested on Marcus one more time. The newspaper story ran on a Thursday. It was not the front page, because a city council vote and a weather event crowded it out. But it was there, with a headline that the reporter who wrote it had clearly considered very carefully. Harrington Foster, the lead attorney who had walked out, released a statement through his firm's communications office. The statement used the phrase "evolving evidentiary landscape" and the phrase "my client's best interests" and did not use the word "mistake." It received the public response that such statements generally receive when contrasted with an 8-year-old in a borrowed shirt. Foster's firm lost 2 clients within a week. They did not make a second statement. Carl Vreeland was charged with theft, conspiracy, and evidence tampering. Gerald Price, in exchange for his full cooperation, received a reduced or charge that his attorney described as appropriate given the circumstances. Alderton's gallery was closed pending investigation. The constitutional letters were returned to the Meridian Historical Archive, where the director spent 40 minutes on the phone with the archive's insurance assessors before hanging up and sitting quietly for a while. Ethan Calloway went back to his glass and steel apartment. He stood in the kitchen and made his own breakfast for the first time. It was cereal. He stood at the window while he ate it, watching the street below, and found himself wondering what he had been missing. He enrolled in an after-school tutoring program that spring, not as a student, as a volunteer. He had heard that the program was run out of a community center 2 blocks from Garfield Street. Marcus Webb got a new composition notebook. The dollar store on Clement Avenue had them in a different color now, a deep green, but the marbled pattern was the same. He dated the first entry. November 1st, he wrote in his careful, leftward-tilting handwriting. The window in the lobby of the Garfield building was fixed. It has been broken since August. Mrs. Reyes on the 2nd floor said she had been asking about it for months. I don't know why it took this long. He chewed his pencil for a moment. November 1st, continued. The boy from the 42nd floor downtown came to the community center today. He is going to help with reading tutoring. He brought a box of cereal for some reason. He seemed nervous. I think he is not used to places like this. I think he will learn. Marcus closed the notebook, put it back in his bag between the reading textbook and the extra credit math worksheet. His mother called from the kitchen. Breakfast. He went. He had things to do today. He had things to watch. The city was always doing something that required attention, and Marcus Webb had decided a long time ago that the most useful thing a person could be was someone who noticed. Not someone who made noise, not someone who demanded things, just someone who paid attention, wrote it down, and was willing to stand up when standing up was what the moment required, even in a too big shirt, even with a hole in the sole of his left shoe, especially then. 6 months after the trial, a law professor at the State University gave a lecture to her second-year students about the nature of evidence. She had built part of her lecture around the Calloway case. She showed the class a photograph of the composition notebook, reproduced with permission. She talked about confirmation bias. She talked about the way investigators sometimes look so hard for what they expect to find that they stop looking for what is actually there. She talked about the institutional blindness that allows entire systems to miss the obvious because the obvious is sitting at a window that nobody thought to look through. Then she asked the class a question. What does the Calloway case tell us about who gets to contribute to justice? A student in the 3rd row raised his hand. He said that it demonstrated the importance of community involvement and civilian observation. The professor nodded. That's accurate, she said. And? No one spoke for a moment. She pointed to the image of the notebook on the screen. An 8-year-old child without legal training, without credentials, without any of the markers we associate with expertise, noticed what 47 professionals with every marker of expertise missed. She paused. The question I want you to sit with isn't why he saw it. The question is why we were surprised that he did. She turned off the projector. Justice doesn't always look like a marble courthouse. Sometimes it looks like a window ledge and a composition notebook, and a child who was raised to pay attention and never told there was a limit on who got to care. Think about that when you're writing your briefs. Think about whose eyes you're missing. Think about who you're not asking. The classroom was quiet, the right kind of quiet. Did this story stay with you? Hit that like button and subscribe for more powerful stories about ordinary people who refuse to accept that justice was someone else's responsibility. Every week we bring you real and richly imagined narratives about the moments when the world's smallest voices said what the largest rooms needed to hear. Turn on notifications. Share this with someone who needs to be reminded that paying attention is its own form of courage. Stories like Marcus's remind us that justice doesn't belong to institutions. It belongs to anyone willing to write it down.